Welcome to Law Crest, your trusted source for understanding the truth about America's laws and your legal rights under the U.S. Constitution. Today, we're re-answering one of the most important and often misunderstood questions in American law. Can police legally enter your home without a warrant in the USA? The short answer is sometimes yes, but under very specific and limited circumstances. In the United States, your home is considered one of the most private and protected spaces under the law. The Fourth Amendment to the U.S. Constitution guarantees every citizen the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. This means, in simple terms, that the police can not just walk into your home whenever they want. They usually need a search warrant signed by a judge, based on probable cause that a crime has been committed, or evidence of a crime exists inside your home. However, as with most laws, there are exceptions, and understanding those exceptions could be the difference between protecting your privacy or losing it. Let's start with the basics. A search warrant is a legal document that authorizes law enforcement officers to enter and search your property. To get a warrant, police must first convince a judge that they have probable cause, a strong reason to believe evidence of a crime is located at a specific place. This could include witness statements, surveillance footage, informant tips, or physical evidence. Once a judge signs the warrant, it must specify the exact location to be searched and what the officers are looking for example, illegal drugs, stolen property, or weapons. Without this judicial approval, any evidence the police collect inside your home is generally considered inadmissible in court, meaning it can't be used against you. That's how strongly the law protects the privacy of your home. But here's where things get interesting. There are certain exceptions where police can legally enter your home without a warrant, and most Americans don't even know about them. The first and most common exception is called exigent circumstances, FIS. This means if the police believe waiting for a warrant would put someone's life in danger, risk serious injury, or allow a suspect to escape or destroy evidence, they can enter your home immediately. For example, if officers hear screaming, gunshots, or signs of violence inside your house, they can lawfully break in to protect life or prevent harm, even without a warrant. Similarly, if they're chasing a suspect who runs into your home during a pursuit, they can follow. That's known as the hot pursuit rule. These situations are time-sensitive and rely on police judgment, but courts usually support these entries if they're based on genuine emergency conditions. The second major exception is consent. If you, or someone who lives in your home, voluntarily gives the police permission to enter, they don't need a warrant. But here's the catch. The consent must be freely and knowingly given. If police pressure, threaten, or deceive you into allowing entry, that consent can later be challenged in court. You also have the right to limit consent, such as saying you can enter the living room, but not the bedrooms. Once consent is withdrawn, officers must leave immediately, unless another legal reason allows them to stay. Many people make the mistake of letting police inside because they are nervous or feel they have nothing to hide. But remember, once they're inside, anything illegal they see in plain view can be used as evidence. The third exception involves plain view doctrine. If an officer is legally inside your home, whether due to a warrant, consent, or emergency, and sees illegal items like drugs, weapons, or stolen goods in plain sight, they can seize them without a separate warrant. But this only applies if the officer is lawfully present to begin with. They can't peek through your window from the street and claim plain view. Another scenario where police can enter without a warrant is when they're performing community caretaking functions, like checking on someone's safety. For example, if a neighbor calls 911 saying they haven't seen an elderly person in days and fear they might be hurt, police can enter to perform a welfare check. Similarly, if they respond to a house fire or medical emergency, they can enter the property to assist. However, they can't use this as an excuse to conduct a criminal search unless evidence is clearly visible while they're lawfully inside. One of the most controversial exceptions is probation and parole searches. If you're on probation or parole, your constitutional rights are somewhat reduced. Probation officers or police may have the authority to search your home without a warrant if your supervision terms include such a condition, especially if they suspect new criminal activity. Courts justify this by saying probationers are still under government supervision. Now, you might be wondering what happens if police enter your home without a warrant and without a valid exception. In that case, the law is on your side. Any evidence they collect can be thrown out of court under the exclusionary rule, which prevents illegally obtained evidence from being used in prosecution. This rule exists to discourage law enforcement from violating citizens' rights. For example, if police enter your home illegally, find drugs, and arrest you, that evidence is likely inadmissible, and the case could be dismissed. But there's more. Not every unlawful entry automatically means freedom for the suspect. Courts look carefully at the totality of circumstances, meaning they consider whether officers acted in good faith or whether the violation was intentional. For instance, if a judge later decides the officers truly believed they had consent or were preventing harm, the evidence might still stand. That's why every case is unique. Let's explore an example. Imagine police knock on your door, claiming they received a noise complaint. You open the door slightly to talk. If they see illegal drugs or a weapon in plain view behind you, they can enter immediately without a warrant, because evidence of a crime is visible from a lawful position. But if nothing's visible and they push their way in, that's illegal entry. Another example, if they believe someone inside is being harmed and hear screams, they can break in. However, if they simply suspect something with no clear evidence or emergency, they need a warrant. Major Supreme Court case, Payton v. New York, 1980. Established that police cannot enter a private home to make a routine arrest without a warrant. The court ruled that the home is a sacred space under the Fourth Amendment and that forced entry without judicial approval violates fundamental privacy rights. On the other hand, Brigham City v. Stewart 2006 reaffirmed that officers may enter without a warrant when they have an objectively reasonable basis to believe someone is injured or in danger. These rulings together show that the balance between safety and privacy is delicate but clear. Emergency saves lives, but privacy preserves freedom. It's also important to note that landlords, neighbors, or guests cannot give police permission to search your private spaces unless they share joint access. For instance, a roommate can allow entry to common areas like the kitchen or living room, but not your locked bedroom. Similarly, hotel managers can take consent to a search of your room while you still checked in. Police need either your consent or a valid warrant. If police do show up at your door, the best thing to do is stay calm and know your rights. You can ask politely, "Do you have a warrant?" If they say no, you can decline entry respectfully, but firmly. You can say, "I do not consent to any search." You are not legally required to open the door unless they present a warrant or an emergency is happening. It's also wise to avoid arguing or physically blocking officers. Simply assert your rights verbally. Remember, everything you say or do can be recorded and used later, so staying composed is key. Sometimes, officers use psychological tactics, like saying, "If you've got nothing to hide, why not let us in?" Don't fall for that. Exercising your rights doesn't make you guilty. It makes you smart. Even innocent people can get caught in legal trouble when they allow unnecessary searches. The Supreme Court has consistently ruled that refusing a search does not create suspicion. It's your constitutional right. So, to summarize, police generally need a warrant to enter your home, unless one of these exceptions applies: exigent circumstances, consent, plain view, community caretaking, hot pursuit, or probation terms. If none of these are present, entry is illegal, and any evidence collected cannot be used in court. Your home is your castle, protected by centuries of legal tradition. But knowing these rules empowers you to defend that privacy intelligently. In a world where law enforcement powers continue to expand, understanding your constitutional rights is more important than ever. Moose people don't realize that a simple yes at the door can override years of legal protection. So the next time police knock unexpectedly, take a deep breath, stay calm, and remember you have the right to say no, unless they have a valid warrant or emergency. Thanks for watching Law Crest, where we expose the truth about the American justice system and teach you how to protect your rights, one law at a time. Don't forget to like, share, and subscribe for more real legal stories, shocking facts, and the truth the system doesn't always tell you.